All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our consolidated juvenile cases 17-268 and 17-366. It's the Shoshone Bannock Tribes et al. Versus the Department of Child Safety. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. We have read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellants may proceed.
Thank you, Your Honors. May it please the Court, my name is April Olson, and I represent the Shoshone Bannock Tribes of the Fort Hall Reservation. I will be arguing for 15 minutes today, and I'd like to save 5 minutes for rebuttal, which will be handled by Mother's attorney, Thomas Vierling.
Can I ask you right off the bat one procedural question that's not really in the record, and that is, hasn't the severance trial occurred?
That is correct, Your Honor.
So is there any reason that this case is not moot?
Yes, Your Honor. The case is not moot as long as the dependency is live from the tribe's perspective. And you are correct. While the Superior Court did deny the petition to terminate parental rights and return the children to the physical custody and the home of their parents, the dependency is still active. We recognize that in several months that may no longer be the case, but as of now the dependency is still active.
Okay, thank you.
This Court should reverse the Superior Court's decision to deny the motion to transfer jurisdiction and order the case immediately transferred to the Shoshone Bannock Tribal Court. Alternatively, recognizing the changed circumstances in this case and that severance was denied, this Court could vacate the Superior Court's denial of the motion to transfer jurisdiction and remand the case to the Superior Court based on the changed circumstances and to further evaluate the law. The tribes further ask that this Court confirm that the Indian Child Welfare Act applies to this case based on the tribe's determination of membership eligibility. This case requires the Court to reverse the Superior Court's decision to deny the motion to transfer for 3 reasons. First, the Superior Court did not apply the proper standard of proof to the motion to transfer jurisdiction. Good cause to deny a motion to transfer jurisdiction should be established by clear and convincing evidence, and the burden is on the parties opposing the transfer. The Superior Court did not apply this standard, and in fact did not apply any standard in its decision, nor did it hold the opposing parties to the burden of proof. The Court could remand the case for this reason alone. Second, and importantly, the Superior Court committed an error of law. The Superior Court found good cause to deny the motion to transfer jurisdiction based on a possible change in placement. This is not a permissible ground to find good cause under the federal regulations, under the guidelines, and now under the Arizona Rules of Procedures. And the Department of Child Safety even conceded this point in its brief. Third, the Superior Court abused its discretion when it determined that the tribal court was an inconvenient forum. In the lower court, no party presented evidence that the tribal court was an inconvenient forum, much less clear and convincing evidence. And to the contrary, the tribal court offered evidence that it could accommodate all of the parties.
Well, could accommodate is a little bit different from the forum nonconvenience inquiry.
That is accurate, Your Honor, but
I mean, there are lots of courts. I'm sure there's a court in Wisconsin somewhere that could accommodate the parties, but that doesn't make it a convenient forum.
Certainly, but the burden was on the parties opposing the transfer to establish it was convenient. It wasn't an issue of which court is better. It was establishing that the tribal court was inconvenient, and no party did that. In fact, the tribal court offered evidence that it would allow the parties to appear by phone. It would allow all the parties to participate in the case. In fact, 30 years ago, Mother's case was transferred from Maricopa County to the tribal court, and the tribal court handled the adoption of the non-Indian, of Mother by the non-Indian foster parents, and clearly that was a convenient forum 30 years ago. The court has only improved in technology and time since then.
Was there an argument about forum nonconvenience 30 years ago?
To my knowledge, I don't know, Your Honor. It's just, I think it's helpful to point out that the tribal court was able to accommodate the foster parents who resided in Arizona 30 years ago and could accommodate and could be a convenient forum for all parties today. Finally, the Superior Court was correct when it held that the Indian Child Welfare Act applies to this case based on the tribe's enrollment determination in long-standing federal and state court precedent, including cases from this very court that hold that a tribe's membership determination is conclusive. The foster parents and the guardian ad litem's attempt to characterize the tribe's enrollment decision as fraudulent or unconstitutional is a distraction and an effort to sidestep the decades of federal and state court precedent, and this effort should be disregarded. I will discuss each of these issues in turn. First of all, starting with the burden, the Superior Court erred here because it did not apply the proper standard of proof to assessing the good cause to deny the transfer motion. In fact, the court didn't address any standard in its decision. The standard should be that the parties opposing transfers have to establish good cause by clear and convincing evidence. Both state and federal law support this conclusion. Now, while Arizona law has not specifically applied the clear and convincing evidence standard to a motion to transfer jurisdiction under the ICWA, it has applied this standard to the other good cause standard under the ICWA, which is good cause to deviate from the ICWA placement preferences. In the case of Gila River Indian Community versus Department of Child Safety, the court held that good cause to deviate from the ICWA placement preferences must be established by clear and convincing evidence. Further, in the Maricopa County Juvenile Action JS8287 and the case of Michael v. Michael, the court held that the party opposing the transfer had the burden to establish good cause. And finally, in the recently amended juvenile rules adopted August 30th, 2017 by the Supreme Court, Rule 50.1 holds, and this is with respect to the placement preferences, the party seeking departure from the placement preferences should bear the burden of proving by clear and convincing evidence that there is good cause to depart from the placement preferences. Federal law also supports this burden of proof. The guidelines which this court and the Supreme Court have found to be persuasive has applied the standard of clear and convincing evidence, and that would be F5 at page 4950 of the guidelines. The guidelines state there is a strong trend in state courts to apply a clear and convincing evidence standard, and the department notes the strong trend is compelling and recommends the state courts follow that trend.
Does that purport to apply to a transfer decision
It does, Your Honor.
specifically?
Specifically to transfer. While the regulations do not hold that clear and convincing applies, they cite the numerous state court cases that hold the standard should apply. And they also cite to the guidelines and cite to the strong trend in state courts that this is the standard that should apply to motions to transfer. Clear and convincing evidence is a high burden.
It is, but does it change the outcome in this case? I mean, the facts seem fairly undisputed. The procedural facts seem fairly undisputed. And so are you saying that there are some facts that somehow slip between preponderance and clear and convincing on this record?
Yes, Your Honor, I think it very well could have changed the opinion in this case. Well, the tribe asserts that no party presented evidence at the oral argument that the tribe was a convenient forum. No party presented any evidence. And in fact,
well, but the considerations that all the witnesses, all the evidence, everything is located near to the state court aren't meaningfully in dispute here. So whether we apply clear and convincing evidence, reasonable doubt, or preponderance, does it lead to a different result?
Your Honor, the tribes would assert that it does. The clear and convincing standard is highly probable or with certainty. And the evidence presented at the trial court wasn't highly probable or with certainty. And we don't even know that the trial court would have come to that result because they didn't apply any standard of evidence. And the evidence offered by the tribe, the fact that the court handled the case 30 years ago, the fact that the tribes expressly
handled
stated...
a different case 30 years ago without any dispute as to the forum. So that's, I would say that's slender evidence. But the evidence that I mentioned, the general forum nonconvenience evidence concerning the location of witnesses, evidence, etc., didn't seem to be in dispute. And I don't hear you disputing it today. In other words, I hear nothing about this forum that makes it convenient except the fact that they have telephonic capabilities.
Your Honor, the burden was not on the tribe to prove that it was convenient.
I respect that. But if all the evidence on the record, which is the evidence I've mentioned, points toward forum nonconvenience, then I'm hard, and there's no argument that some of that evidence is less than credible. There is no argument that there's contravening. It's just all one body of evidence saying that the tribal court offers none of the factors necessary. The standard of proof then seems not to be contributing much toward the result. And I will say that leaves aside the issue we have yet to discuss of the court's consideration of an improper factor under the regulations.
Sure. Your Honor, because the tribe didn't have the burden to establish that its court was convenient, it did not proactively present evidence that the tribal court was convenient, that it could have. If, for example, the parties had raised an issue in their pleadings that the tribal court would not travel to Arizona to hear a severance trial, or would not allow parties to appear, or would not allow video or Skype testimony, the tribe then could have rebutted that information with additional information. In fact, the tribe in this case did file a motion for reconsideration after receiving the Superior Court's denial of the motion to transfer, where it held, based on the distance and the no guarantee of telephonic appearances, the court found there was an inconvenient forum. The tribe filed a motion to reconsider, stating that the tribal court judge, the prosecutor, the defense would all travel to Arizona if a severance trial was necessary.
The fact that one party bears the burden, though, does not mean that the other party bears no obligation to put up a defense. When there's enough evidence presented by the party who bears the burden shifts. That's fairly elemental. And so while I appreciate that the tribe didn't have the burden of production or the ultimate burden of persuasion, it actually, as far as I can tell, presented nothing to support its convenient nature at the time of the hearing.
Well, Your Honor, I would respectfully disagree.
Okay.
I think the tribe presented evidence that it would allow all parties to participate, that parties could appear by phone, and again, that the tribal court...
But it did that in a motion for reconsideration.
Your Honor, that information was presented during the oral argument that was held on the motion to transfer.
Okay.
And there was no actual evidence entered at the oral argument. There were no exhibits, there was no testimony, other than the assertions of counsel. And if the court was going to find and make findings based on the evidence and based on the clear and convincing evidence standard, there should have been findings with that respect. Your Honor, with respect to the placement issue, I just want to make a brief statement because I see I'm running out of time. The court based its good cause finding in large part on the potential change in placement. And in its decision, the court noted that the tribes had not asserted one way or the other whether or not they would seek to change placement, and held that the uncertainty of this issue weighs heavily in favor of denying the motions. As DCS pointed out in its brief, this was an improper consideration under the law. Again, under the Bureau of Indian Affairs guidelines, the regulations, and now the Arizona Rules of Juvenile Procedure, a court must not consider in assessing transfer whether or not there would be a change of placement.
Counsel, that was just one of several factors that are in the Code of Federal Regulations and I guess now the juvenile rules. So that's just one factor. That's not completely dispositive. Would you agree?
I would agree. And I would agree that the court got the law wrong on that particular factor. And in the Superior Court, the two main factors that the court relied on to find good cause were the possible change in placement and were the inconvenient forum argument. And with that, I will reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
May it please the Court, my name is Dawn Williams from the Attorney General's Office. I represent the Department of Child Safety. I'll be using half of our time, with the remaining half to be used by the interveners and child's guardian ad litem. Your Honors, the Department's only issue in this matter is whether or not the juvenile court abused its discretion when it denied the transfer motion, and it's the Department's position that it did not. As we conceded, the judge should not have considered whether a change in placement could have occurred as a result of the transfer of the proceedings. But more importantly, the court did find that the tribal court was an inconvenient forum. And on that basis...
Is counsel correct that there's actually a dispute over, that was timely presented over the availability of telephonic appearances?
I believe there was a mention of the possibility of telephonic appearances, but the issue of the tribal court coming to Arizona wasn't raised until the motion for reconsideration.
No, but the court seemed to be under the impression that there was no guarantee that people could even appear by phone in the tribal court. And I'm hearing a disagreement between the sides today about whether that evidence was in the record.
I'm sorry, Your Honor, I'm trying to recall. For the best of my recollection, there was some discussion of possible telephonic appearance, but the concern was that it wasn't a certainty, and that it was also uncertain whether the interveners would be parties in a tribal court proceeding as they were in a state court proceeding. In addition, I think this court needs to keep in mind that this is an abuse of discretion standard, and the juvenile court here relied on primarily the same factors as the court had in JS 8287 in finding an inconvenient forum. In that case, the court said the child had been in foster care under the auspices of the state court for years. The tribe's interest was protected by participating here. The child, parent, and all of the witnesses were present here, and the parent's social history was here. In this case, the court found, again, that the child had been, both children actually had been under the care of the juvenile court for some time, that all of the witnesses and parties were present in Arizona, that all of the service providers who had information about the parent's ability to parent was present in Arizona, and that the tribe, again, had been permitted to intervene and could participate in the Arizona courts. So the court relied on the same factors that this court has previously upheld as a basis for a forum nonconvenience finding. And so on that basis, it's the department's position that the juvenile court didn't abuse its discretion here, despite considering an improper factor when it looked at the placement issue.
So what result are you seeking here?
At this point, because of the change in circumstances, we would like the case to continue. It's on its way to dismissal with reunification with the parents.
Well, I guess on this appeal, the question is what's the proper result? Because there seems to be little pending that is actually of interest to the tribal court at this point. I suppose something could come up. But with regard to the severance trial, the ruling under appeal today is essentially moot. With regard to some possible future proceeding, I'm not sure that a ruling from this court affirming for all time the judge's decision is really necessary.
I think the only issue that is outstanding to the extent that the parties are still here before you is primarily addressing the issue of the standard of proof. Arizona hadn't, until the recent rule enactment, addressed the standard of proof, and there's a bit of a disconnect between the act and the regulations, which permit, for example, the court to bring or to find or to assert good cause not to transfer, and a burden of proof, which obviously the court can't bear.
An advisory opinion at this point?
I think at this point it is. I think when this case was originally brought to the court, there was still a lot in play, and
What's
since
the
that
status of the guidelines that counsel mentioned, that she says call for a clear and convincing standard?
The guidelines recommend a clear and convincing evidence standard. They don't require it, and the guidelines are not binding. The federal regulations, which are binding, don't assert any particular standard of proof. Arizona has since adopted a rule that requires a clear and convincing standard of proof, but that went into effect after these proceedings.
So let me ask you this. Why would this court not simply remand the case essentially for further proceedings on any such motion if and when it becomes necessary, considering the proper factors that everyone acknowledges are binding?
That's certainly an
I'm sorry?
option. That's certainly an option for the court.
Well, it's an option. Is it one that you think would do harm to the department?
No.
Okay.
No, I don't believe so. If the court has no further questions, I'll give the rest of my time to the other parties.
Thank you, counsel.
Please the court. My name is Howard Shanker. I'm here on behalf of the intervener and the GAL, the children. And I would like to clarify a few points. First of all, you're looking to determine whether or not the lower court abused its discretion. And nothing so far has pointed in that direction.
Well,
When you-
consideration of a factor that is absolutely clearly prohibited under federal law could be part
Well,
of the use of
and
discretion.
I'll happily address that. But first, let me point out that clear and convincing evidence is not the standard in a transfer case. And it has never been applied in an Arizona transfer case. And what they're doing here today is arguing that it should be the standard in transfer cases in Arizona. But certainly the lower court did not abuse its discretion when it did not apply a higher standard to the transfer case than has been applied in any other Court of Appeals case in Arizona.
I'm sorry, is it supposed to be a clear and convincing evidence before you avoid transfer? Is that the theory?
There is no clear and convincing
I'm
standard
just hard
that's
for me
been
to understand
applied.
why something that's sort of a basic judicial function, which is deciding a matter such as nonconvenience, would have a higher burden of proof. But
Well, it shouldn't. This is really, as you say, a basic function. When they're talking about clear and convincing, they're applying by analogy, deviating from the ICWA preferences, which is the substance and the basic point of the statute. Here you're assuming both jurisdictions are equally available and able to address the issues.
I don't think we're assuming that. I think ICWA requires us to defer to some measure to the tribal sovereignty. But I guess the question is, all of this discussion about clear and convincing evidence seems a little bit out of place when the proceeding was conducted under an unlawful standard in part in the first place, right? I mean, the court said it weighs very heavily in the decision that this might affect the outcome, and the court is specifically forbidden from considering that.
Well, first, Your Honor, as I said, the court applied applicable law, and there is no clear and convincing or whatever standard. We assume it's preponderance evidence of the evidence.
But you're not really addressing my point. The court applied inapplicable law, and that's my concern.
Well, Your Honor, it applied a few elements, but with regard to the best interests of the child, what you're hearing today is that the 2016 regulations require that the court not consider the best interests of the child.
No. I think what the 2016 regulations require is that the court not consider the likelihood of the impact of a transfer on placement.
Well, that's exactly right, Your Honor, and that's what I mean when I'm referring to the best interests of the child.
I mean,
The problem,
it's
Your Honor-
possible for fact finders to differ.
Well,
And
I agree
so-
with what you just said.
And so for the federal regulations essentially to tell the courts, hey, don't make these decisions to stack the result, is a pretty clear command that this judge did not follow.
Here's the problem, Your Honor. The 2016 regulations at 25 CFR 23.143 specifically say that they do not apply to proceedings that were initiated prior to December 12, 2016, which means this court, because the dependency was filed on August 11, 2016, the petition was filed on August 11, 2015, the 2016 regulations do not apply to this case.
The request to transfer was filed after the effective date of the regulation.
But the proceeding was initiated, which is what the law says, in 2015.
Well, it depends, I suppose, on how you read the term proceeding, but if you have a petition that happens to be filed the day before the effective date, and then the transfer consideration doesn't come up until a couple of weeks after the effective date, do you really believe it's the intent of the regulation not to apply?
Yes, Your Honor. Okay. This is a dependency proceeding. It's not a transfer proceeding. We're talking about the case at large and when it was filed. And this, as the law states pretty expressly, the 2016 regulations do not apply, which means that the older regulation or the older guidelines might apply, as well as whatever law is out there. The lower court specifically relied on an Arizona Court of Appeals case that was directly on point when it considered the placement of the child. It did not abuse its discretion. Now, if the case or the dependency was filed after December 12, 2016, clearly it would not have been able to consider that as a factor. But in this case, it didn't abuse its discretion by applying Arizona precedent that was specifically on point.
Do you agree that if the case had been commenced by any definition after the effective date of the regulation, that the court would have abused its discretion?
On that issue, yes.
Okay. So let me ask then you the same question that I asked counsel for the department. Why at this point, given the relative stasis in the case and the fact that the trial has already happened and the issue is essentially moot, why would we not simply dispose of this case by an order instructing the court that if a motion to transfer comes up again, to apply an appropriate standard without resolving this case for all time on the merits?
Well, that's up to the court, Your Honor.
Well, I know it's up to us, but is that something you would oppose?
We also have our cross appeal that's in place, and that could certainly impact the outcome of the cross appeal. But I would also like to point out that the placement, and that again was not abusing the court's discretion, was only one factor. As you discussed, the court applied a modified form of forum nonconvenience, which is well accepted. The facts were not at issue. And with regard to the telephonic participation, the court said, although the tribe argued that parties might be permitted to testify telephonically during any proceedings in tribal court, there's no guarantee that the appearances would be permitted. Furthermore, it makes no sense to transfer the case to tribal court, forcing virtually every witness and party to the proceeding to appear telephonically in another jurisdiction when they can all appear in person in Maricopa County. That's not an abuse of discretion. That does not go beyond the bounds of reason. As you indicated, there is no dispute that all of the parties are here in Arizona. All of the evidence is here in Arizona. The parents' criminal records are here in Arizona. The children are here in Arizona. The services being provided are here in Arizona. Is it an abuse of discretion for the court to say, well, maybe this is a better forum to hold the hearing? It's not. And on that basis alone, transfer should be upheld. And again, clear and convincing evidence is not the applicable standard in these cases. And again, the 2016 guidelines do not apply to this case. And even if they did, transfer should still be, the denial of transfer should still be upheld. Now, the tribes say that our cross appeal is a distraction. And I understand that it's a difficult issue to deal with. But under no circumstances could these children be eligible for enrollment or membership in the tribes.
Let's say you're right. Under what circumstances does this panel have the ability to address that question?
Well, the state courts are the final arbiters as to whether or not ICWA actually applies in any given case.
State courts are not even preliminary arbiters, though, as to tribal membership.
And that's true, Your Honor. The tribes have the ability to define who they call a member and who they allow to become a member.
Right.
And the tribes did that when they drafted their constitution and their ordinance.
Interpretation of a tribal constitution falls far outside the scope of this court's authority.
Although the Constitution says that you cannot be a member unless you were born to a member on the reservation when you were born there. It doesn't require.
I've seen a lot of decisions from courts that I disagree with, but I don't necessarily have the authority to overrule them. We only have the legal authority to address the questions within our jurisdiction. tribe is a sovereign entity, and I don't see how, no matter how right you are about your argument, I don't see how it's cognizable in this court.
So this court would essentially hold then that the moving party bears the burden of establishing that ICWA applies unless it's a tribe, which has never been stated in the law before. So there must be something more. I don't know that you can give the tribes a pass for bad behavior. I mean, that's essentially what seems to be going on.
I think that's I would not agree with that rather inflammatory characterization of a tribe's exercise of its sovereign authority, but I don't think it's controversial at all to suggest that there are limitations on state authority to apply and interpret tribal law.
Well, I definitely appreciate that, Your Honor, and I agree with the sentiment. My position, obviously, is that it doesn't really require any interpretation. All of the organic and governing laws of the tribe say that these children are not eligible for enrollment. But that being said, I will just simply reiterate that the lower court did not abuse its discretion in the transfer decision. And if there are no further questions.
Thank you.
Thank you, counsel.
Thank you.
May it please the court, I'm Thomas Beerling, I'm attorney for appellant Jessica S. My summary of the facts shows that the tribe informed the juvenile court that parties and witnesses can appear in tribal court by phone or video conferencing, and I think that can be found on page 16 of the transcript. A strict reading of the convenient forum requirement would lead to a potential finding that would be contrary to congressional findings and goals that are incorporated into ICWA. This may mean that only children living on or near a reservation can have their cases transferred to a tribal court. The technology and the ability of the tribal court to hear was presented to the juvenile court, and they were capable of handling all matters. Otherwise, these children, because of the place where their parents choose to live, would not have an opportunity to have cases transferred to the tribal court.
Well,
where,
but it's also conceivable that you could have children who have parents and relatives who are scattered all over the place. Some of them near the reservation or on the reservation, some of them far away. The children may be near or close. There may be multiple children who are in different locations. Every case has to be evaluated on its own facts. So I don't think that if the forum nonconvenience decision here is upheld that it implies a significant erosion of ICWA.
well, in the circumstance where the tribal court informed the juvenile court that they were available telephonically and through video conferencing, and also later on a motion for reconsideration that the tribal court would hold its hearings at the Gila River courts, which is in Maricopa County, that doing a finding that simply because witnesses are here would deprive the children of having their cultural court hear their case, simply because there are witnesses located here. Otherwise, we have children who are Sioux or from other tribes who are living in Arizona. This argument could be used repeatedly against them to deprive them of the congressional goals of having them have their culture make the determination as to what is in their best interest. In addition, with regard to why this matter should still be considered, the parents can face a severance petition, a severance motion, adverse decisions that may be contrary to their cultural heritage. And that is why this decision from the court is important, so that the proper foundation would be heard in the tribal court.
Do you believe that the regulation's effective date renders the regulation still applicable in this case?
I haven't seen any law on that, in terms of when to look at that. With regard to the regulation's effective date, I do understand the case was existing prior to that. The problem in this case was the notice issues to the tribe. The tribe didn't receive notice until later, which actually led to a late filing of the transfer. They could have gone in earlier, but in any event, the case law from other jurisdictions state that the finding on convenient forum has a lot to do with whether or not the tribe is willing to make itself available. So I don't, if it,
But no, I think that doesn't go to my question. One of the concerns expressed initially was that the court had relied on a prohibited factor. Given the effective date of the regulation, was that factor prohibited or not?
I believe so if you look at decisions from other jurisdictions.
Okay.
And I cited some of those in my brief. And if the court doesn't have any other questions, that would be fine. Thank you.
Thank you, counsel. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.